Good afternoon once again, everyone, and welcome to commemoration of the African Union Anti-Corruption Day, running on the theme Ending Impunity for Grant Corruption. And also the subtitle, sub-theme of today's session is also in tandem with the African Union's theme of the year, that is restoration of human dignity in the fight against corruption. And ours is expansively stated as asset recovery and the role of an international anti-corruption court. I'm sure most of you, ladies and gentlemen, you agree with me that grant corruption, top-level corruption, has led to massive resource drain, not only in Africa, but mostly in Africa, given the dire situation of the continent. I can give several examples, but time will fail me. But just try to imagine every time you switch on international news, you will see a number of Africans dying or in desperate situation, trying to cross the Mediterranean Sea, Sahara deserts, and if they do make it, doing manual jobs in the West, even under near-slave conditions, or recent news headlines where Africans are being forced in a situation where they have to beg for development aid. The paradox of it being that what is lost through corruption, money laundering, and illicit financial flows is more than what is way more than what Africa is way less rather than what Africa is getting through development aid. And today I have a number of experts and other practitioners, commentators who are going to speak on the topic. But before we do that, I would like to invite Kugan to give some opening remarks. Thank you.
Thanks, Prof. Prosper, for those remarks. So, colleagues, as the co-chair of the Africa Group on anti-corruption, I'd like to support Prof. Simba on the warm welcome that is extended, and I'd like to make a few remarks on this important occasion. Firstly, it's important on the occasion of the 22nd anniversary of the inception of the African Union Anti-Corruption Commission, which came into being in 2003. It's also important given the devastation wreaked by corruption on development and human rights.
Good morning, everyone.
It's also important, as many of you know, it's Mandela Month. And Mandela was a global icon for human rights. And human rights is at the very core of freedom, equality, dignity. You might remember when former UN High Commissioner Navi Pillay, who shares my surname, but we're not related, we just happen to be colleagues and good friends, but she made the remark when she was a Human High Commissioner then, that corruption is not victimless. Corruption robs the citizens of their livelihoods, and most often the vulnerable and the poorest of the poor, including in some cases taking away their lives. We've seen that with whistleblowers like Babita Deokaran in South Africa during the height of the COVID pandemic. It's also important that it's occurring now, and it happens to coincide with the first time that South Africa and Africa are hosting the G20, with the overarching theme of sustainability, equality, and solidarity. And colleagues might know that within the G20 group, there's also a subgroup called V20, or Values 20. And I'm privileged to be part of this group, that's led by Professor Bonang Mohale and co-chairs. And I'm responsible for a stream on corruption and advancing transparency, integrity, and accountability. One of the key values within the V20 group is the concept of Ubuntu, which relates to people's existence with each other. And there are other key values that the team is looking at, such as ethical governance, integrity, and accountability. The topic is certainly appropriate presently. I don't know if anyone watched the breaking news a few hours ago when South African athlete Caster Semenya, after 6 years, won a ruling in her favor at the European Commission of Human Rights, with the world body previously preventing her from participating unless she injected hormones into her body. And that's because she had an advantage, a so-called advantage, due to her makeup by birth. Further, this past week, we've had explosive revelations in South Africa with very senior ministers in government being exposed for corruption, with colleagues coming in and blowing the whistle. And we've also had an assassination on a whistleblower. So all this talks to the impact of corruption on people's dignity. And I think this afternoon we have esteemed speakers who will present on the topic itself on corruption, the impact of corruption on people's dignity, and other important topics such as asset recoveries, which will certainly advance the UN Sustainable Development Goals, which many of you will know that have been derailed to the extent that we are presently informed that we are 17% on track. So I think it's an exciting time to hear the colleagues, and Program Director, I hand over back to you. Thank you.
Thank you very much, Co-Chair, for such wonderful remarks. And indeed, corruption is not a victimless crime. It does have victims, and these victims, they deserve to have their dignity intact. So without much ado, I would like to now call Justice Maria Wilson, who is also a member of the Africa Subcommittee, to present a keynote address on why human dignity must be central to the fight against corruption. Judge, your turn. Judge, I think you are muted.
Right. You hearing me now, everyone? Yes.
Yeah.
Greetings to our distinguished guests, colleagues, fellow panelists, and to persons who have joined us from the African continent and beyond. And good afternoon, good evening to you all. Or if you're on my side of the globe, good morning. I feel honored and privileged to be here with you today. I am a member of the board of the Integrity Initiatives International, and I'm here on their behalf. And I'm also here on behalf of the IACC Court Africa Subcommittee. But I'm also here as a Trinbagonian, a national of Trinidad and Tobago, as a mother of 2 Tanzanian children, and as a person of African roots, to be part of this ongoing effort to ensure that there will be no impunity for kleptocrats, senior leaders in countries who continue to use public funds for private gains, whether in African nations or in the numerous nations around the world where there is corruption. I applaud you all for working tirelessly towards this worthy goal, generally, and in relation to the African continent. Today, we have come here to acknowledge the importance of this journey and to honor the African Union's vision in adopting the Convention on Preventing and Combating Corruption on the 11th of July, 2003. We mark this pivotal accomplishment in the celebration of African Anti-Corruption Day, which will be commemorated tomorrow on the 11th of July, 2025. African nations have been generously endowed with vast wealth in terms of its natural resources. But unfortunately, such wealth often attracts corrupt practices from individuals who wish to enrich themselves to the detriment of African nations. The vision held by the African Union to prevent and combat corruption some 22 years ago continues to be very relevant to preserve the resources of this African continent, not only for the current generation, but for future generations of African nations. And moreover, to protect and ensure human dignity for our African brothers and sisters. The theme of this year's African Anti-Corruption Day is promoting human dignity in the fight against corruption. And what exactly do we mean by human dignity? And how can we promote human dignity in the fight against corruption? So I first look at what do we mean by human dignity. In a book entitled Perspective on Human Dignity, A Conversation, the author discusses the philosopher Kant's concept of human dignity, which Kant refers to as the worth or value that a person has simply because they're human, not by virtue of any social standing or their abilities to evoke admiration or any particular skills, sets of talents, or power. What he refers to as intuitive dignity is the value that human beings have by virtue of the fact that they are human beings. The Universal Declaration of Human Rights, adopted by the United Nations General Assembly in 1948, enshrines and captures this concept of human dignity. In its preamble at Article 1 and 2 respectively, it recognizes the inherent dignity and the equal and inalienable rights of all members of the human family as being the foundation of freedom, justice, and peace in the world. And also stated in the Article 2 is that the peoples of the United Nations have in the Charter reaffirmed their faith in fundamental human rights, in the dignity and worth of the human person, and in the equal rights of men and women, and have determined to promote social progress and better standards of life. And the General Assembly went on to proclaim the Universal Declaration of Human Rights as a common standard of achievement for all peoples and all nations, to the end that every individual and every organ of society, keeping this declaration constantly in mind, shall strive by teaching and education to promote respect for these rights and freedoms, and by progressive measures, national and international, to secure their universal and effective recognition and observance, both among the peoples of member states themselves and among the peoples of territories under their jurisdiction. The Constitutive Act of the African Union and the African Charter on Human and People's Rights recognize the respect for human dignity as a cornerstone of governance and unity on the continent. An integral part of the objectives and principles of the African Union Convention on Preventing and Combating Corruption is the respect for human rights, rule of law, and transparency as fundamental elements of human dignity. So next week, now that we know what human dignity is, how do we promote human dignity in the fight against corruption? The goal of promoting human dignity in the fight against corruption is really a call for us to pursue the fight against corruption from a different perspective. We are being called upon to adopt a people-centered approaches. This is transformative. It calls on us to refocus and reframe our efforts, recognizing that corruption is not only a legal offense or an economic burden, it is a violation of the human spirit. It reminds us, as someone was saying earlier, that corruption is not a victimless crime. Yes, we focus on ensuring that the kleptocrats who use public funds for private gain are held accountable, but we must not forget what it means in real terms. The daily injustices faced by individuals, which erodes the very essence of what it means to live with dignity. So individuals might have to go to overcrowded hospitals when ill, resulting in difficulty in obtaining basic health care. Children might have to attend under-resourced schools, which prevents teachers from meeting the educational needs of their students. Missing social grants might mean that poor, disabled, and senior citizens are unable to provide for their daily needs and the needs of their families. It might also result in whistleblowers, what's so important in this whole corruption drive, anti-corruption drive, of losing their jobs and being threatened, exiled, or silenced. There's so many more examples of victims of corruption who are unable to live with dignity because of the difficult situations they face. Even the persons who have lost faith in the system and pay bribes to obtain contracts from governments, they too feel less worthy because they believe they're forced to take such actions to meet their financial needs and that of their families, because that is the way the system works. A people-centered approach means that anti-corruption efforts must not merely be reactive or punitive. They must be proactive, inclusive, and anchored in justice. It means prevention measures must prioritize equitable access to public services and fair distribution of resources. It means that the investigations must respect due process and protect all persons involved in the system, victims, witnesses, and suspects. It also means that prosecutions must be impartial, with respect for the rule of law, and with safeguards against abuse of power, political manipulation, or selective justice. Perhaps most importantly, it means that citizens, especially whistleblowers, must be protected, heard, and empowered. In essence, human dignity in the fight against corruption means human dignity is not a peripheral objective. It becomes the very heart and soul of the anti-corruption movement. Importantly, we need to engage in prevention measures, such as ensuring equitable access to public resources, prioritize inclusivity, and also encouraging civil society to create mechanisms which individuals can utilize safely to make their voices heard. So it calls upon us to refocus and reframe our efforts, to remember that corruption is not only a legal offense or economic burden, it is a profound violation of human rights. It robs individuals of opportunities, strips communities of trust, and erodes the very essence of what it means to live with dignity. So here we are, some 22 years later, after the formation and the joining of this convention. And how far have we come in achieving the principles we aimed at to achieve? Well, we have seen commendable progress in legal reforms, asset recovery, digital governance, and citizen-led initiatives. However, as with most other countries in the world, corruption still pervades our institutions. Too many of our citizens still feel unheard, unseen, and unprotected. So this year's theme is indeed a wake-up call. And if our anti-corruption efforts are to succeed, they must be centered on the lives and lives experiences of people. So we need to focus on restoring dignity and not just enforcing discipline. And so in closing, I would like us to remember that anti-corruption is not only about removing the kleptocrats, it is also about building good. It is about creating societies where dignity is not earned, bought, or negotiated, but respected as a birthright. And we must never forget that, I mean, we see a lot of statistics from Transparency International, so, but we must never forget the faces behind the statistics, the voices behind the reports, and the lives behind the laws. Let us make this fight human. Let us make it personal, and let us make it dignified. And at this juncture, I would again like to applaud African countries for their national efforts in this fight against corruption. We are prepared to support you in any way we can in achieving your goals. As we know that we are promoting the creation of an international anti-corruption court. And as much as we like to do things on a national scale, we have to admit that there are at times powerful perpetrators of corruption who escape justice because our national systems are unable to deal with them. Either because the leaders or the persons in national courts, they feel powerless and they are unwilling or unable to investigate and prosecute. So we want to remind you that we are here to support you. And if for some reason the national system fails, the purpose of the International Anti-Corruption Court is to provide a mechanism where in those circumstances where leaders are unwilling or unable to prosecute or investigate, that we can play a role in that. So it's not a primary jurisdiction, but it's what we call complementary. So the court will hope to send a strong signal to the international community that it will no longer tolerate grand corruption and impunity that destroys the lives of so many people, not only in Africa, but in different countries. So I encourage you to continue your fight against corruption. And remember, it's not just a national struggle. The International Anti-Corruption Court is there to assist you in this fight and to ensure that there's no impunity for kleptocrats, whether in the African continent or any other part of the world. So thank you very much for giving me this opportunity to share with you my position on this amazing day when we celebrate the vision of the African Union. Thank you very much.
Well, we would also like to thank you very much, Justice Wilson, for your insightful presentation. We truly appreciate your time and perspective, especially on the people-centered approach to fighting corruption. No doubt this will be a game changer in restoring the dignity of those whose lives have been ravaged by corruption. Now, ladies and gentlemen, we now move to the next segment of our commemoration, which is the panel discussion. And as mentioned before, we are glad today to have three distinguished speakers. Each will speak for 10 minutes. I'm very good at timekeeping. I respect judges. The judge went over by 3 minutes. I didn't interrupt. No worries. But for the rest of the panelists, I'll be very time conscious. So now I would like to introduce and also invite our first speaker, who is also the Director of Good Governance Africa, Dr. Bello. I hope Dr. Bello is in the room. I have a blind side. I could not see everyone who is.
Good afternoon.
Yes, thank
Good
you.
afternoon.
Good afternoon. We can hear you loud and clear. And please, if you can take the virtual floor.
Okay, thank you very much, Chair. Thank you for the opportunity to address this August gathering. I know that you want to help us manage time in a very disciplined manner, so I would fully subject myself to this process. I aim to speak for just about 3-4 minutes in the first instance, and when you give me the opportunity, I would be more than happy to address a few of the other things that I had in mind when I was asked to address this gathering. At the heart of what I want to do is to preach to a converted church. And that's in the sense of, helping all of us gain a much more richer, much more encompassing sense of the kind of virus we're talking about when we broach the subject of grand corruption. I'm not sure if the organizers have chosen me to speak about this precisely because I'm sitting in Lagos, Nigeria these days, or that they think I eminently have something important to contribute to this discussion. But that goes right to the heart of one of the things I think is not often captured in this debate. You see, when we talk about the question of grand corruption, I've been asked to address its human impact. Its impact is human in so many ways, and that there is that single dimension that people do not often appreciate. The way that it just distorts and skews. And I think that's the very heart of where I think corruption has most hurt Africa. As somebody who lives in Nigeria today, I'm all too aware that one of the things it does, sometimes to channel opportunities to where it's not sought, and at the same time denying those very opportunities to segments, to population and demographies and other parts of society where those opportunities are most needed. When we talk about, its impact on social sector, educational investment that made have forgone because money have gone into private pocket, we'll talk about those. But this is the heart of what I really wanted to address with our colleagues and friends gathered here today. That corruption, where it's at its most sophisticated and where what we call grand corruption becomes pervasive, all members of society become a victim. Whether you are, part of the corruption dynamics in society or just as a passive victim. So it goes right, I think, to the very heart of what human dignity means, of our very humanity. I did not want to be, an anti-corruption spokesperson, but I'm sure part of the consideration is that the country where I sit today is particularly affected by this. And it probably, and I would think legitimately, is one of the reasons why I've also been asked to address this conference. So, just in terms of defining then comprehensively what, grand corruption means, there's an element that relates to power. I call it an empowered form of corruption. Unlike your petty corruption, which may be orchestrated by an individual or just a group of people who are involved in what you might call a racket. People who have got their own things going on. Grand corruption is empowered because it operates at a very systemic level with the levers of the power of state also channeled to its services. And I think this is the reason why it's not just a major scourge that our societies in Africa need to redouble effort on addressing. It's also important to address it because it operates in the shadows. The people who are orchestrators of it are well able to hide away from the prying eyes of the public because of the empowered state offices that they occupy. And by definition, this also makes it something very difficult to address head on. And in that sense, and I work for Good Governance Africa has been doing over these past couple of years at least to be part of the effort to ensure, the bringing into existence of an international anti-corruption court that I hope in the course of the next few years will begin to work much more closely with empowered authorities in Africa, but also society at large, to ensure that this court can be part of addressing impunity where it exists, bridging the gap where the capacity to bring grand corruption, to justice is a particular challenge, but also to send out a clear message to all of those empowered actors who are authors and orchestrators of grand corruption, that, a new sheriff is in town, the rules of the game are changing, and that the days of impunity may well firmly be in the past, and that there is not just the means and the tools, but also the collective political will on the part of society, the global society, to bring, people who are involved in this form of corruption to heels. If you give me the opportunity later, Mr. Chairman, I want to also acknowledge the excellent work that actors like the African Union have been doing on addressing grand corruption. But I think at this time, I should probably then hand over the mic, consistent with the promise I made with you at the outset to keep my opening remarks rather brief.
Well, thank you so much, Dr. Bello, for those insightful remarks. And yeah, that gives us a lot to think about. But ladies and gentlemen, if you do have any questions, compliments, comments, please for now just hold on to them. We have time for this. Now I want to shift to the next speaker. But before that, I mentioned that we have each speaker will get 10 minutes, except for Dr. Charles, for the next speaker, Dr. Charles Phillips, who is going to get 20 minutes. Some of our speakers will get extra time, yeah, not because they talk too much or too more, but because we need time to figure out and understand exactly what they are saying. Well, jokes aside, I would like to invite Dr. Charles Phillips, who is also a subcommittee, a member of the Africa III subcommittee rather, and also a former prosecutor of the tribunals for Rwanda, the international ICTR, International Criminal Tribunals for Rwanda. And Dr. Charles, if you are ready, the floor is yours.
Thank you very much. Thank you very much, and good afternoon to everyone. I wouldn't bore you by giving you an elaborate introduction of myself or what I've done in the past. Suffice it to say that I have made an art form of being involved in international prosecutions and international asset recovery. Let me start off by saying the first point I need to make is that experience has shown that stolen asset recovery is not merely a legal process. It's a deeply political one, and I'll tell you why. The process of tracing, recovering, and repatriating illicit funds to victim countries in and of itself involves many technical and procedural obstacles, which, in my view, significantly impedes asset recovery efforts of victim countries in Africa. Now, such obstacles, in my view, can vary from a complex or a complete lack of state cooperation and extends to the outright obstruction by several governments in some jurisdictions. The central question, in my view, therefore is, who should control recovered assets and under what conditions should such assets be returned? Before I answer that, let me start off by telling you a little story. In 2014, the first vice president of the Republic of Equatorial Guinea, a man called Mr. Theodoro Obiang, who also happened to be the son of the Equatorial Guinean president, had surrendered over $30 million worth of property, including luxury cars and a collection of Michael Jackson memorabilia, to the United States Department of Justice as part of a settlement of a money laundering probe by the US government. But sadly, that was not the end of his legal troubles. Following a criminal complaint filed by two civil society groups in France, the French authorities in 2010 or 2011 commenced an investigation into how Mr. Obiang had acquired a property in France, in Paris, France, and the said property comprised of a 5-story mansion in Paris. Now, shortly after the French police searched the mansion and seized a collection of luxury cars therefrom around 2011, the Embassy of Equatorial Guinea in France, in an attempt to shield those properties from enforcement, then informed the French government that it had actually purchased the said building from Mr. Obiang, and that it was now using that building or parts thereof as part of the embassy's premises, thus claiming that it formed part of its diplomatic mission to France. Interestingly, no such claim was made against the luxury cars, which consisted of Lamborghinis that were found in that property. Now, thoroughly unimpressed by the argument of the Equatorial Guinean government, the French government refused to recognize either the diplomatic inviolability of the building itself or of Obiang's purported official immunities as the vice president of the Republic of Equatorial Guinea. Mr. Obiang himself was subsequently convicted of money laundering by domestic courts in France, and the property in question was ordered to be forfeited to the French government. 2 years later, in 2016, Equatorial Guinea then instituted proceedings against France before the International Court of Justice, the ICJ, seeking to prevent France from selling the mansion, alleging violations of the Vienna Convention on Diplomatic Relations, to which both Equatorial Guinea and France are contracting parties. In its judgment of 11th December 2020, the ICJ ruled that the diplomatic immunity being claimed by the government of Equatorial Guinea did in fact not extend to the Paris mansion, whose forfeiture had been ordered by the French court. You would have thought that would have been the end of it, but it wasn't. In 2022, the government of Equatorial Guinea then returned to the ICJ and instituted proceedings against France, this time alleging that in failing to return the Paris mansion to it, France had failed to comply with its asset recovery obligations under the 2003 United Nations Convention Against Corruption, otherwise known as UNCAC, to which both Equatorial Guinea and France are contracting parties. The case is currently pending before the ICJ, and the ad hoc judge appointed by Equatorial Guinea happens to be a Nigerian. In essence, Equatorial Guinea relies on Article 51 of UNCAC, which provides as follows. The return of assets is a fundamental principle of UNCAC, and state parties shall afford one another the widest measure of cooperation and assistance in this regard. They also rely on Article 55 and 57 of UNCAC, which places obligations on contracting states to give priority consideration to returning to the requesting or victim state confiscated property whose return it has requested, and to extend to such states the cooperation and assistance required to that end. Now, these two cases are yet another demonstration that the main barriers to the prosecution of high-ranking foreign officials for economic crimes are practical and political rather than legal. Now, in my view, the absence of a unified international policy governing the repatriation of illicit funds to victim countries creates significant obstacles in the enforcement recovery mechanisms. Mutual legal assistance agreements designed to facilitate cooperation between jurisdictions are often hindered by bureaucratic inefficiencies and the conflicting legal standards, some of which I've already pointed out. In many cases, victim countries remain at the mercy of legal systems never designed to prioritize their interest. Someone has spoken about Nigeria, and I speak to you from sunny Lagos, Nigeria this afternoon. And in that regard, Nigeria's prolonged recovery of the Abacha loot from Switzerland lasted over 2 decades. Theodoro Obiang's luxury assets seizures in France and the US, which I've only just spoken about, exemplify how these challenges can stall asset repatriation for years and also underscore the difficulties in fully tracing and reclaiming illicit wealth. Now, beyond the legal and political complexities that I've spoken about, the practice of enabling countries in deducting the expenses incurred by them during the investigation of the repatriated funds has been widely criticized by the African Union. Through the Common African Position on Asset Recovery, they have insisted that victim countries should not bear the financial burden of retrieving assets that were unlawfully taken from them. Instead, the Africans and the African countries through the AU argue that enabling countries should absorb this cost as a form of reparations for having facilitated illicit financial flows in the first place. On the other hand, enabling nations have maintained that asset recovery is a resource-intensive process requiring extensive legal proceedings, forensic investigations, and intergovernmental negotiations. The disputes over cost sharing continue to complicate the already arduous path to repatriation. Perhaps the most contentious aspect of asset recovery lies in what is called the repurposing of recovered funds. This is a practice whereby enabling countries stipulate to victim countries how the assets being repatriated should be utilized by the receiving state. Now, proponents of repurposing will argue that such conditions are necessary to promote transparency and to prevent the misappropriation of the repatriated funds, whilst the recipient nation often view such conditions as an infringement on their sovereignty. Key examples are in connection with Nigeria's recovery of the Sani Abacha loot, wherein Switzerland insisted on allocating the recovered funds to specific developments managed by international organizations. Similarly, in Equatorial Guinea, the government of the United States, in recovering the assets stolen by Theodore Obiang, directed the funds towards the COVID-19 response efforts in Equatorial Guinea. Now, the conditions imposed by enabling countries, while ensuring that the recovered funds are not misappropriated or relooted, as we say, these conditions highlight the tensions between victim countries in Africa, exercising their rights of sovereignty in determining what to do with such recovered funds, and the need for some degree of oversight by the returning country. Now, recently, 2 prominent accountability models have emerged in the stolen asset recovery debate. These 2 accountability models are, one, a global model, as evidenced in the assets chamber of the proposed International Anti-Corruption Court, and the African asset recovery agencies being proposed by the African Union. Let me start off with the proposal of the African Union, which I have described here as an Afrocentric solution. That Afrocentric solution consists of the following. One, a centralized African asset recovery agency to provide technical assistance and coordinate legal efforts and act as a unified voice for African nations in asset recovery matters. It also proposes for a dispute resolution mechanism to mediate in conflicts between African nations and enabling states, such as the one I just talked to you about, going on between Equatorial Guinea and France, and also to prevent legal and diplomatic deadlock. Again, refer to the Equatorial Guinea and the France case, playing out as we speak. The African solution also proposes capacity building initiatives aimed at strengthening financial institutions and anti-corruption agencies to ensure that African nations can effectively engage in asset recovery proceedings. These initiatives, in my view, highlight Africa's determination to move beyond reliance on Western-led legal processes, which historically have favored financial security over restitution. Now, let me talk a bit about the proposed international solution. It consists of two things. The first proposal is by the United Nations High-Level Panel on International Financial Accountability, Transparency, and Integrity. They have called for the establishment of public registers and registries which would contain and reveal the beneficial ownership of property and assets in order to prevent illicit funds from being hidden in very complex corporate offshore trust structures. They have also called for the stronger international cooperation in mutual legal assistance to expedite asset recovery cases. In addition, the international NGO community has called for and spearheaded the establishment of an international anti-corruption court, which is part of what we're speaking about this afternoon. The proposed international anti-corruption court is intended to serve as a judicial body with the power to prosecute grand corruption cases through the use of a non-conviction-based civil asset forfeiture mechanism and a conviction-based asset recovery process. The essence of the court is to ensure the swift and efficient return of stolen assets to victim countries, in addition to making those responsible for grand corruption accountable, criminally accountable for their crimes. So how does the IACC propose to do things? Well, there are two legal pathways in the IACC towards the recovery of illicit funds or assets. One, as I said, is the criminal conviction-based forfeiture procedure. The other is the non-conviction-based civil asset forfeiture procedure. Now, I want to talk about these two processes for about 2 minutes. To my mind, the criminal conviction-based forfeiture can be often ineffective in cases involving high-profile politicians or where the accused person is at large or enjoys political protection. In addition, because of the adversarial system of justice applied in most common law countries, high evidentiary burdens exist, and this tend to prolong legal proceedings, and lawyers like myself would take strategic legal maneuvering measures which can further complicate the process of asset recovery through a criminal litigation process, accountability process. So whilst the criminal prosecution procedure ensures legal rigor, it is often seen as a very impractical way of recovering the loot, as most defendants will simply dig in once they're charged with a criminal offense. And I will come to that in terms of the historical nature of Africans and criminal charges and how they react to it. So the fundamental distinction between the two models that I have mentioned lies in their jurisdictional reach, the IACC being global and the African solution being continental. Critics highlight that the African solution's regional limitation may pose as a major challenge, as much of the stolen wealth is hidden offshore, is hidden in offshore accounts and in financial hubs outside the continent of Africa. So the argument being that the limited regional reach may be an impediment to the functioning of such a court or such a body. Now, in essence, without binding international cooperation mechanisms, the African solution may struggle to enforce asset repatriation from foreign jurisdictions. Because whilst the proposed IACC's global scope would make it significantly more efficient at tracking and retrieving assets that have been fueled through complex international financial networks, the African solution may have some challenges, like I pointed out, in that regard. Additionally, the African solution's institutional link to the AU, which has historically struggled with the inconsistent enforcement mechanisms amongst its own member states, is likely to be another weakness. On the other hand, the IACC, by the nature of its functioning, which is independent of national governments, may be insulated from this sort of domestic political pressures. Also of concern, and which is perhaps very important, is that the African model is yet to outline robust safeguards to prevent relooting, which is a real and live tendency in many of these African countries. My point is that without stringent oversight, the risk remains that politically connected elites would divert recovered assets, which would then in turn defeat the very purpose of the asset recovery efforts. So whilst the African solution may seek to impose conditions on how the funds are used, its ability to enforce these conditions, in my view, remains terribly uncertain. Now let's go back to the two models that the IACC proposes, the conviction-based and the non-conviction-based forfeiture. For me, based on the stigma associated with criminal accountability, which sadly is often viewed in Africa as a process only reserved for the poorer members of society, there will be little or no incentive for the alleged perpetrators of grand corruption to either surrender the illegal assets, the illicit assets, or to cooperate in the tracing and recovery of such assets. Well, why? Well, in my view, because in essence, the notion will be that, well, if I've already suffered the public humiliation of being placed in handcuffs as an African leader, what useful purpose would it serve for me to surrender or assist you in tracing the stolen assets? You've already humiliated me before this world court anyway. So experience has shown that the perpetrator's cooperation is very essential for victim countries in unraveling the whereabouts of assets concealed in very complex trust structures. We've experienced it here with the Abacha loot. Now, having said all that, let me point out that the fear, just the mere fear of an ICC prosecution might be the beginning of wisdom for many perpetrators. The very prospect of an ICC indictment may be capable of serving as a negotiating tool to encourage the voluntary surrender of assets by politicians. Now, one of the limitations of the criminal prosecutions is in relation to financial institutions and corporations. And I'm sure you've been waiting for me to say, well, Charles, what about the corporations and the people who actually hold the money? Well, experience again has shown that there is a reluctance to make financial institutions face criminal prosecutions. And therefore, the criminal prosecution procedure may be ineffective in dealing with such institutions charged with corruption or laundering the proceeds derived thereof. Let me give you an example. The first ever criminal conviction of a financial institution for money laundering offenses was that of the UK NatWest Bank, only in 2022, where they pleaded guilty to money laundering and were fined almost £300 million. Now, in contrast, if we look at the non-conviction based approach, I believe that the non-conviction based approach would allow for the voluntary surrender and or forfeiture of assets suspected to be prima facie proceeds of unlawful conduct. This method, by the way, is endorsed very widely by the United Nations. However, this method requires the active cooperation of the perpetrator. Why? Well, as we have found out in Nigeria, dealing with the Abacha loot, Nigeria has found out in its quest to seek the return of the Abacha loot, banking secrecy laws in some jurisdictions have historically shielded illicit assets, making them extremely difficult to trace and recover without the active cooperation of the defendant. This, in my humble view, makes the non-conviction-based procedure being proposed by the International Anti-Corruption Court a much faster alternative. In addition, the recent trend in the United States and the United Kingdom is indicative of the fact that the enforcement of money laundering violations against banks and other financial institutions have ended up in deferred prosecution agreements, which allow banks to pay fines without admitting guilt or facing criminal convictions. Based on this obvious reluctance to prosecute financial institutions for anti-money laundering violations, in my view, the non-conviction-based approach would be very useful as a civil forfeiture-based enforcement mechanisms. And I give you 3 examples. In 2020, Goldman Sachs paid over $2.9 billion in fines following the 1MBD corruption scandal it was involving the government of Malaysia. In 2012, HSBC faced another $1.9 billion settlement with the US authorities for failing to prevent money laundering, primarily by Mexican drug cartels. In 2024, only last year, Credit Suisse's role in the Mozambican tuna bond corruption scandal costed $500 million in penalties to the US, UK, and Swiss regulators. So these 3 recent cases, in my view, highlight the fact that even the most robust penal legal frameworks can fall short when faced with the influence of powerful financial institutions and the influence they wield over regulatory decisions. Therefore, it is my view that if properly structured, the proposed IACC would create a legal backdrop for disputes over stolen wealth. However, for the IACC to be effective, in my humble submission, African states which make up majority or a substantial number of victim countries must play an active role in shaping its mandate. In that regard, only yesterday, the 9th day of July 2025, a criminal complaint was filed by some of my Belgian colleagues before the federal prosecutor in Brussels against 9 members of the family of the President of the Democratic Republic of Congo, Felix Tshisekedi. The suspects, who includes the president's sister-in-law, his sons, his brothers, his cousins, and even the president's wife, the first lady of the DRC, were accused as accomplices to acts of corruption and other criminal behavior in connection with the looting of mines in Upper Katanga province. Now, I have no doubt that such a criminal complaint could never successfully have been filed before domestic courts in the DRC. This, in my view, only reinforces the view that the proposed IACC's independent legal framework, its international reach, and its emphasis on transparency would, in my humble view, position it as a superior and a more sustainable approach to the recovery of illicit assets to victim countries in Africa. I thank you all for listening.
Wow, that was so clear and compelling and good. I almost forgot I was supposed to moderate and not just sit and enjoy. Thank you, Dr. Charles Phillips. Ladies and gentlemen, as we come to the end of our panel, I would like to close by calling Mr. Enoch Koma, who will bring in the learning and development perspective to the fight against corruption. Mr. Koma is working as a senior manager on learning and development with the Special Investigation Unit in South Africa. Mr. Koma, if you are ready, the floor is yours.
Thank you so much, Chairperson. My name is Enoch Koma. I'm Senior Manager at the Special Investigating Unit. I first wish to extend the sincere apologies of the head of the Special Investigating Unit, Advocate Andy Mutibi, who would have loved to be part of the session. However, because of other commitments, he could not be part of the session. From a learning and development point of view, I am very honored and privileged to be part of the conversation and to be given the opportunity to share my views on a very critical role of capacity building in the fight against corruption. I would also touch on why it is important for the proposed IACC to play a critical role in the area of capacity building to ensure effective investigations, prosecutions, as well as civil litigation. As I start, I would really like to state that I've been captured by two phrases of the previous speakers, more so by the Honorable Justice Maria Wilson's speech in particular, the aspect where I quote, she says, "How do we promote human dignity? We need," she says, "to pursue the fight against corruption from a different perspective." She further go on to say, we need to refocus. I would like to add to that, to then say that, yes, we need to refocus. We also need to reposition. We also need to realign, and we need to redefine. I'm saying that because we need to do all of that in relation to an effective response to evolving financial criminality. That compels us to refocus. That compels us to come up with different perspectives on how we deal with the challenge of corruption, in particular, grand corruption. I would also like to start by saying that I have also been captured by Dr. Charles Phillips' presentation, in particular around Afrocentric solutions, when he says capacity building initiatives are critical to strengthen anti-corruption agencies. He goes on when he talks about the international solutions. Then he draws our attention to beneficial ownership, the question of public registries that should be kept up to date, and the promotion of transparency and accountability through these institutions, be it deeds institutions that deals with trusts accounts, be it institutions that deals with registries of companies. The question of beneficial ownership is very critical. It therefore means that we are faced by a complexity, a growing complexity of financial crime, where grand corruption is defined as follows. Grand corruption, which refers to a large who abuse their power and influence and to accumulate wealth, and this involves complex schemes. Here's and to build the necessary complexities that would be able to investigate and prosecute those that are involved in grand corruption. Grand corruption is corruption really that takes place at a high level, where people at that level conceal or hide the proceeds of crime through beneficial ownership and other means that are very complex, in particular, the complexities of money laundering. In order for us to have an effective proposed IACC as anti-corruption agencies across the continent, we are therefore compelled to capacitate ourselves with the necessary competencies that will be able to enable ourselves to unravel grand corruption. Because those that are involved in grand corruption are in fact involved in a covert way. How do we then unravel that covert method, be it concealments, be it through complex corporate structures where they hide their natural persons or their identity, be it through a number of other structures, be it through NPOs and a number of other structures? How do we then deal with those? It then becomes a challenge. The establishment of the International Anti-Corruption Court will be a challenge if it is met by anti-corruption agencies which are unable to table their cases in a winnable way within that particular structure. We are therefore challenged to equip ourselves around this. South Africa, for example, in recent years, have been grey-listed through the Financial Action Task Force. These didn't only highlight the need for effective legislation to come into place, which we had to promulgate, be it the General Laws Amendment Act and other acts that deals with combating of financial terrorism, that deals with money laundering. That grey listing by FATF have really raised the need for us to begin to ensure that we become effective in our legislation. We come up with effective legislation so that we can deal with beneficial ownership, terrorism financing, illicit financial flows, etc., etc. The grey listing of our country have highlighted the need for effective investigations. It has highlighted the need for effective prosecutions. It has highlighted the need for effective litigation in order to ensure asset recovery and confiscation. So in order really to combat money laundering, we have to build on these capabilities. An international court focused on corruption could provide a critical platform for holding perpetrators accountable and promoting global cooperation in the fight against corruption. However, for such a court to be effective, it is essential that those that bring matters before it are capable and well-trained in handling complex financial crime cases and should understand the intricacies of money laundering, amongst others. It is paramount, or it is of paramount importance, that the proposed IACC makes it its duty to build capacity and expertise in fighting corruption. Through training and knowledge sharing with anti-corruption agencies in respect of its role, its objectives, its jurisdiction, etc. It is exactly for this reason that the head of the Special Investigating Unit have envisioned the establishment of a premier learning institution for our continent, based in Pretoria, which is the SIU Anti-Corruption and Cyber Academy. This institution has recently been launched, and it would serve as a regional hub and a pioneer for collaboration that would host various expertise from across our continent: legal minds, forensic accountants, data analytics experts, etc., to promote the sharing of information and best practice in the continent. This is a stride towards effectively dealing with financial crime, in particular in the view of the proposed IACC. Chairperson, I'm not sure whether I should continue. My paper is quite long. If Chairperson wants me to continue, I will do so. I don't want to take much of your time.
I'm so glad to give you a minute to give us your strongest points.
Chairperson, my strongest points really are towards the conclusion. I will go to the conclusion. And in my conclusion, I have outlined opportunities that one proposes in respect of the IACC. One is also sure that experts might have done that even better. And I have also highlighted challenges of such an envisaged court. Not being a legal person myself, I'm merely a head of learning and development. One, it's the opportunities that are there. This court, it's an important court, has highlighted that it would hold corrupt leaders accountable, and it would promote good governance. And I'm sure that the expert of good governance would agree on that. It would really help in recovering and repatriating stolen assets. The only challenge for me would be for the court not to be viewed as a biased institution. That's where I'm going to end. Thank you so much, Chairperson.
Likewise. Thank you so much, Enoch. And also to all the speakers, really, thank you for your thought-provoking insights. So we now have some time for questions from the audience. I'm sure you're really eager to join in the conversation. So what we will do now is I'll simply raise your virtual hand, and Pusetso, if you can also assist me here in identifying those who have their hands raised.
Sure.
Yes.
There was a hand earlier from Jane Colvin. I see it has been put down. I don't know if Jane still wants to
perhaps the question has already been covered by Enoch. I don't know. Well, but please, and also one point before we proceed to the Q&A, please keep your questions short and direct so that we can have as many questions as possible.
I see Dr. Oladiran Bello has his hand up. And who else? Yes. And Rose Seretse also has her hand up. So I will say Dr. Bello, and then after Dr. Bello, we'll have Ola Tunji, and then Seretse. So those three.
With your permission, Chair, just to come back with one other quick remark. I'm particularly happy that, you know, when I scan through the participant list, I see a few familiar faces, some of them well-known legal experts. So I think I will be correct to say in large part, we're here in a gathering, if not dominated by, I would say significantly shaped in the direction of its conversation by people of a legal background. I'm a political scientist. I'm a political economist myself, and what I do is around governance. So the alarm I wanted to ring here is that first, I had a lot that encourages me from some of my co-panelists, but I also have to come with a disclaimer here. I wanted to ask if we've all looked at the progress of the International Criminal Court over the last 3 decades. I think it would not be misplaced to say, the result from trying to crimes, war crime against humanity around the world, there's been some progress, but oftentimes the perception is that it's been underwhelming, and there's disappointment from so many quarters. So I wanted to ask, to what extent are we convinced that another legal mechanism, this time specifically focused on anti-corruption, will be sufficient on its own? And I say this for 2 reasons. The first is, I think, what Charles Phillips has also alluded to in some of his remarks, and I think our two other panelists, besides myself, have also alluded to this to some extent. There are limitations when you look at the possibility of offering corrective to global to grant corruption merely through prosecution on its own. I am somebody who has worked on the African extractive sector for the last 25 years. It's also true to say that a lot of what we refer to as grand corruption oftentimes are directly linked to some of the misgovernance and inadequacies that we have in the way that we manage Africa's natural riches. I think it's the ground zero of grand corruption. It's where it's often been too easy for those who are empowered, to feather their own nest over and above the head of citizens. So that's the first point I wanted to make, that I do not think, legal mechanism on its own will be sufficient. The other complementary point I wanted to make.
Thank you. Sorry, Dr. Bello. Sorry, brother. I hate to interrupt you, really, but I think that was quite a handful. Let's hold on to that, attend to other participants, and then we may come back to your second question, if that's okay with you, if there are no violent objections.
That's fine, Mr. Chair. That's
a
very
number
fine,
of lawyers that you acknowledged here, but William Shakespeare once said there's a matter of priority. Let's first queue all the lawyers. But anyway, let's get to other participants. Professor, if you can help remind me again, who's
Sure.
the
We have Ademiju Olatunji.
Yes.
So I have allowed you to speak. Please go ahead. Olatunji. I'm going to mute the person for now and allow Mrs. Rose Seretse to speak. Ms. Seretse? Oh, okay. There is Olatunji. Please go ahead.
Okay, good morning, everybody. Thank you for your fine presentations. I have a number of comments, but I'll try to make them very brief. I think the starting point is for us to look at how we define corruption, what it entails from a third world perspective. Are we defining corruption to also include acts of those who participate in ensuring that the wealth of Africans are kept away from them? Like Justice Maria Wilson said, when we talk about corruption, we should talk about dignifying the victims. And if we agree that corruption keeps people poor and it brings about all those horrible things we see in African states, then the issue of participants should be something we should take care to consider. Otherwise, we will just be whitewashing the acts of the developed world who keep the wealth in their countries to further develop it and impoverish Africans. Apart from the issue of definition, we can also think about the issue of assets recovery. How do we ensure that we can recover assets timeously? I am doing a research on grand corruption and the role of the IACC as a PhD student. And to my mind, I think a Ganishi-like approach, which is used in civil proceedings in Nigeria in recovering assets from debtors, from court judgment debtors, may be a good tool the IACC can look into and see how it will work. But we should also not forget that when we talk about assets recovery and grand corruption, it has we should look at it with the lens of an international political economic perspective, because it will change power balances. It has economic implications for both sides of the global world, both the global north and the global south. So these are things that we should also think about in thinking about whether the courts will be effective. We can start thinking about, how the ICC as an institution has fared, the lessons we can draw from the ICC. We can look at other regional institutions. How will the court be structured in a way that the activation of its jurisdiction will not bring about allegations of bias by countries, especially African countries. And, it comes back to this issue of definition. When you talk about grand corruption in the context of international money laundering, you cannot point at corrupt political leaders in Africa without looking at the roles of financial institutions and other actors in the global north. For example, just Dr. Hadiogun Phillips talked about the role of Nguema, the case of Nguema, but what is left out is the role of lawyers who kept opening accounts, who kept, when one account is closed because a lawyer raised money laundering issues, they open another account. The role of real estate agents who kept ensuring that these transactions pass under the radar of the different regulations they have. These people are never prosecuted. They are never so they weren't prosecuted, and I think it is something we have to think about. Otherwise, it will just be like resounding what we know already. Yes, we have corrupt public officials in Africa. We have them in some parts of the developed world as well. But the role is not just to tell us that our leaders are corrupt. We want the money, and we also want to see consequences for those who help them in keeping the money away from Africa. Thank you so much.
Indeed. Thank you. Thank you, Olachichi. And can I remind speakers to keep your questions very short, precise, and very direct. So I think we still have one more, and then I'll allow
Yes,
the
we
two
have-
panelists to respond.
We have Meru Sreze. Meru Sreze, you're allowed to speak. Please go ahead. Can I unmute?
Hello, can you hear me?
Loud
Yes,
and
we
clear.
can.
Yes, thank you very much. And I really appreciate the presenters for the very insightful presentations. The IACC is a very welcome development, but the question that I have, which is also a concern, is what mechanisms, because there's been, like the last speaker said, there's been concerns that seems like the international courts target African leaders. So what mechanisms will be put in place to at least give the leaders in Africa confidence that it is not targeting African leaders, it is meant for everyone? I think if that sort of assurance can be provided, it's a welcome development. And then also Enoch talked about the learners development. I think prosecution-led investigation is one key aspect, particularly for our anti-corruption agencies, that should also be put in place to ensure that prosecutors within the anti-corruption agency are always there to guide the investigations for evidence that can stand the test of time. Thank you very much.
Thank you. Thank you. So to our panelists to hear the questions, but I would also like to allow Justice Wilson to also respond if you do want to respond. I see you nodding a few times, and I think some remarks have been made about your presentation as well. We have about 3 minutes to respond to the questions. Thank you.
Okay, I'll be very quick. Dr. Bello made a comment about the ICC, and basically there were some negative comments about the ICC. So why should we go with this separate mechanism? Firstly, there's a gap in the international enforcement regime to deal with corruption offenses. We know there's UNCAC, etc., but there's a gap. The kleptocrats are still not being held accountable. That's one. So secondly, the ICC deals with a different jurisdiction. I mean, I work there as a trial lawyer. They deal with crimes against humanity, genocide, war crimes, and crimes of aggression. So it's not within their scope to deal with this. To change their room statute to implement it will take very long, and it will be too complicated for them to deal with such serious offenses as well as corruption. I feel that you should not judge this proposed court by the ICC. The ICC had unique is unique in what they were addressing. And so that was my comments to you. There was also the comments about, well, the other thing too is the ICC will be a more efficient court. I mean, the IACC will be a more efficient court. There'll be no pre-trial chambers. We will not have a standing judiciary. We'll only engage judges as they're needed. We will use courtrooms of other courts, and we will use, we'll get our revenues from maybe the fines that are imposed on individuals. So we intend to have a more efficient court and a more effective court with expert judges, expert prosecutors, and expert investigators. Did I answer anything else? And okay, there was a perception of the ICC that is only going after African leaders. Just to be fair, in reality, there were state party referrals from those countries, for example, Uganda, etc. The other thing is that now is the time we have discussions such as this to make sure there's participation from the African continent in saying what they want the court to look like. We don't want it to be a Eurocentric court. Hence, we have these sort of exchanges and consultations. So feel free to tell us what you think the court should look like, so that the court will not have, the proposed court will not have that reputation of only going after African leaders. Thank you.
On that note, sorry, before I allow other panelists, I think we are also glad to have Justice Richard Goldstone, who is quite familiar, with the court, prospective court. If Richard, you can also, if you do have something you may want to add on, please, before we move to the other two questions.
Oh, well, thank you very much, Professor Simba. I'm happy to keep my remarks at the end. If that's still the program, I see I have 5 minutes to suggest next steps, and I'm prepared to leave it at that. Thank you very much.
Indeed. Thank you also very much for saving us time. So now, other panelists, I think, Charles, are you still in? And Enoch? There was a question on asset recovery.
Yes, I am.
Yes, Charles, there was a question from Olatunji on asset recovery, and I think this question, another question on defining corruption. That was a general question that can be answered by either you, but I think also Mr. Koma also went a little bit into the definition. But please, Charles, on asset recovery, how timelessly can it be made? Justice delayed is justice denied.
Thank you. I always say all the fora that I have addressed had the opportunity to speak on the court. And I do identify with a comment of the speaker, who in essence says, well, you know what, we want our money back. And for someone who lives in a victim country and spends half of my time in a victim country, but was educated and practices law in an enabling country, I understand that point. And I often say that, look, whilst criminal prosecutions serve as a deterrent, they cannot build schools and hospitals and roads in victim countries. And of course, the proposed International Anti-Corruption Court will be looking to hold accountable everyone that is perpetrator has been involved in the perpetration of this crime, whether or not they're enablers in terms of professionals, lawyers, accountants, and doctors. And that's why I gave the examples of the banks that have been held to account, maybe not necessarily through a criminal prosecution method, but certainly through a non-conviction based accountability mechanism, which this court has going for it anyway. So I don't see any reason why those categories of people would not be held to account. Justice Wilson has dealt with the issue of perception of the ICC in Africa. I say that all the time, and she's given reasons why the IACC it will be different in structure to the ICC.
Thank you. Rose, do you feel like your question has been answered? I think we still have. Oh, all right. So I think Jane, you had your hand up. Jane Colvin.
I think Jane is not in the room, but I see Dr. Bello's hand is up.
Okay. We also,
Again.
all right. So Dr. Dr. Bello, you were also a panelist. Would you want to respond, or this is a question?
Thank you, Chair. Just you know, a final remark from me, which I think you know, in a way nuances what I was trying to say earlier. I appreciate the remark by Justice Wilson. You see, I was, as a non-lawyer, I'm not trying to, you know, be smarter than the lawyers. What I was simply trying to allude to is, as somebody of a governance background, the way that I think people who occupy the legal world and those of us who work around governance and standards setting in Africa can much more work closely together. In a way that I think over time would in fact strengthen the work of the International Anti-Corruption Court. You see, there's been so much angst around Africans being targeted because where a lot of the malfeasance are visible, you would expect an international criminal court or an international anti-corruption court to be much of its searchlight. So I do not think Africans are disproportionately targeted. I just simply think that there is a lot we need to strengthen around our governance. African economies are also disproportionately reliant on the extractive sector, where a lot of this grand corruption tend to happen, as is clear in the case of Equatorial Guinea, that has also been cited as an example here. So very concretely, what I want to call our attention to is my belief that deterrence oftentimes does not equate prevention. An international anti-corruption court, I think, would be a very would be a viable form of deterrence to intending participant in grand corruption, but it would be far better if we strengthen institutions in Africa in a way that we're able to prevent a lot of these things becoming a problem in the first place, such that they overwhelm national, prosecutorial capabilities, or even some of these international mechanisms that we're trying to put in place. And if you have any doubt, look to the United States today. Mr. Trump, a lot of what is happening in that country, there is a U.S. Anti-Corruption Act that's been so well respected around the world, which with the stroke of a pen this year has been swept away. So I do not believe the challenges for Africa reside solely in weak internal systems. I think some of the challenges are also around how you make something systemic. And there's a lot that's been going on in the area where I work. We talked about the African Union. What has it been doing in this area? There are only two, remarkable, visible initiatives on the part of the African Union when it comes to addressing the question of anti-corruption in Africa. There is the AU Convention on Anti-Corruption, but also some of the work that have been done around the Africa peer review mechanism. For a continent so hobbled by grand corruption, I think we need to do a lot more. A lot more is required. So some of the work we're doing around standard setting in Africa, including things like the, Africa mining vision, some of what we're trying to do around, contracting standard for the extractive sector in Africa. We would like to invite some of our, brilliant legal minds to close ranks with us, so that some of these initiatives are not just things that have the, the political gravitas to change behavior in Africa and outcomes, but also the legal, underpinnings robustly to make them deliver for Africa. Those were the things I was alluding to. I like the court. Initially, I was pessimistic about it, and then I saw the possibility. Today, I am looking at the possibility of permanent progress. I'm a champion of it. I'm not at all pessimistic about its ability to help, change the narrative for Africa. Thank you, Mr. Chair.
Thank you. Thank you, everyone. Thank you. Really, you will have to forgive me. I think we need to move to the next important segment of today's seminar. So I'm going to call upon the Vice Chair of III, Justice Richard Goldstone, to guide us, to give us a brief on the next steps for African advocacy.
Oh, thank you very much. I would really want to make two points about next steps. I think the first is perhaps I can take one step back. I think we must recognize that all of the remedies we're talking about, all of the institutions we're talking about, are in no way contradictory of each other. They are in fact complementary. So I think the first step is to recognize the crucial importance of domestic remedies, and for every country in Africa, to the extent it can. And I'm not talking about the kleptocracies. I'm talking about the democracies and the countries where they have governments working as government should work. I think the first step is to really strengthen the domestic institutions that have been set up to fight corruption, and the International Anti-Corruption Court is in no way a substitute for these domestic institutions to operate. It's crucial to recognize that the International Anti-Corruption Court will act as a complementary body. It will only step in when domestic institutions are not doing their work, when there's huge corruption, grand corruption at the top government levels that are not being investigated. It's in those situations that the International Anti-Corruption Court will step in. The second the most immediate next step that needs to be taken in relation to the International Anti-Corruption Court is for African states to weigh in on the draft statute which has just been prepared by Integrity Initiatives International. We have worked extremely hard for the last 18 months. I'm happy to say that Justice Wilson has played a crucial role in this endeavor, as too has Dr. Charles Adiogun Phillips and many others. We've had over 100 experts, really leading experts from around the world, weighing in and helping us produce this first draft of a statute for the International Anti-Corruption Court. Crucially, many of those experts have come from our own continent, from Africa. And we've been, especially Integrity Initiatives International, has been very careful to ensure that we have had input from all continents, and perhaps particularly from the African continent. We bore in mind very much the sort of attitudes and understandable views which have been expressed again today, criticizing the International Criminal Court as being, at least in perception, as being anti-African or biased in the selection of its cases to include cases from Africa. Whether that perception is correct or not doesn't matter. The perception is there, and that perception is a fact. And for that reason, we have taken and will continue to take every step possible to make African governments feel that they are being included, that their voice is important. And this draft statute which is being prepared is being shared at this stage in confidence with any governments that are interested, and there are many on the African continent who have expressed their interest, and with whom we are already in the process. In the last week or so, we're already in the process of sharing that draft statute with them, and we are looking forward to and welcome the responses from those governments. So this is really Africa's opportunity to get in on the ground floor, on the bottom floor, to influence the way in which the International Anti-Corruption Court will work. So those are the two steps: strengthen domestic institutions and come and help us, African governments, African NGOs, because we're looking at civil society as well. It's not only governments, but we want the input from all over our continent to influence the shape that the court will take when it's eventually formed. Thank you very much for your attention.
And thank you also, thank you very much, Justice Goldstone. That was quite really compelling, really, and a powerful message to different partners, stakeholders here to be in the engine room in terms of advocating for this statute. We can't really wait for the statute to be made public, to be available for public scrutiny. Now, ladies and gentlemen, we come close to today's event, and I would like to call upon the vice chair, co-chair rather, of the African subcommittee of III, Mr. Suraj, who is also going to give us some final remarks, but to also help us to reflect on what we have heard today from all these fantastic, wonderful speakers, and yeah, help us to reflect as we move forward and carry the conversation forward. Mr. Suraj, if you are in, please unmute your mic and take the floor.
Thank you very much for being such a very, in a positive note, you know, a very strict moderator. And I would want to start with the appreciation to you first and foremost for not only providing the service and also doing it brilliantly and excellently done. We want to also go ahead to appreciate all the lead speaker, Justin Maria Wilson, Dr. Charles Adeogun, Dr. Ladiran Bello, and all the other contributors, Justice Richard Goldstone. Yes, we really thank you so much for providing those insights and also some of the clarifications. I think what Justice Maria Wilson said, the task for us in combating kleptocracy, grand corruption, and illicit financial flow, cross-border crime is basically not just about removing the kleptocrat alone. It also goes beyond that to spread across and strengthen the challenges of dealing with weak mechanisms and institutions in Africa. And more importantly also would be to dealing with the enablers, which are more some of our professionals, including the bankers, the auditors and the accountants, sadly the lawyers as well, the property managers and the estate agents. These are very critical players that without them, I was recently talking to one of the chair of the anti-corruption agencies in Nigeria, and my very radical proposal was that there's an urgent need to possibly suspend the operations of the bureau, the change in Nigeria. If we succeed in doing that for within 1 or 2 years, I can assure you that not only that the propensity for the illicit financial flow would be reduced drastically, it would also assist in improving the value of the naira, because majority of all these public office holders still in billions of naira, which has already been reduced to almost worthless paper, prefers going to convert it to dollars. And when you have these highly unregulated mechanisms that allows for these changes, it enables the corrupt practices. And we've seen that with the prosecution of many of the high-profile cases that is always involving the movement of money to the bureau de change, and from the bureau de change moving them abroad. So it is very critical that we look at where are these opportunities that we have. The bankers are always there as well, and it is for me about showcasing what we have and what we're able to do at home. And just like Justice Richard Goldstone said, the IACC is not to supplant what is supposed to be the power and the responsibilities of the state. It is only after the failure of those mechanisms, the national mechanisms and local mechanisms, that we want the IACC to step in. And unfortunately, if care is not taken, we might end up having the same similar situation that we're dealing with the ICC, because you will find out that the more of the corruption cases going to IACC would be more from Africa. And it will only then be seen like Africans are just the one that will be the target of the court. So it's very critical that we in Africa, as part of this committee, start building the mechanisms and also preparing ourselves, because the IACC would then ultimately be one of the rescue mechanisms, because we still have very weak institutions. We have very unfair and compromised electoral systems that are not allowing for people with integrity and dignity to assume political office. And the last point also made that I would want to help us to reflect on deeply more is what Justice Wilson said about corruption also going to erode the human dignity. Sometimes, you know, it is not just about even the corrupt themselves. Those of us coming from those countries that are touted as the corrupt nations, it impugns on our integrity and also undermines our dignity. You can imagine where you appear at the airport and you stretch out your passport, and my Nigerian colleagues that are here and those who travel a lot can always tell you that the first sense of suspicion, it is either for cyber criminality or which is called 419, or corruption. And that is where you get vetted more than every other person, because everybody is suspected to be the same. The leaders are not respected. The US system has just reduced just few days back the number of years from 5 years to just 3 months for an average Nigerian visa, American visa to be issued to Nigerians. Now, I mean, this is utterly ridiculous. Unfortunately, it is part of the erosion of the dignity and also the failure of some of the system, irrespective of, you know, the failings of the current American system and also the American president. But it's the fact that we are also presenting ourselves. And I saw that there was a meeting with the US president by the African head of states also last night, where quite a number of them were spoken to in a manner that is more degrading than that of even the dogs. The dogs are treated better within the American system, but it's because they lack the integrity, they lack the moral authority to stand up and challenge such situations, because there are quite a number of them that have been compromised in one way or the other. So dealing with the issue of grand corruption has to be from home, and we also have to hold those enabling environments, including the foreign banks and foreign property markets, the foreign institutions that allow and assist in the stealing and the illicit flow of funds from Africa to destinations in America, France, now Dubai, and the UK. Once again, on behalf of the committee, I thank all the speakers, all the participants. We really value your participation, and we would want to see you also being part of the subcommittee. Your contributions are very, very highly appreciated, and more so, we would want to see them as part of the shaping of the process that would ultimately lead to the emergence of the IACC. I thank you once again for your attention and wish us all a wonderful day.
Well, thank you, Mr. Siraj. And my key point, takeaway point from your closing remarks is that even the dignity of some African leaders, some of them who are also publicly known to be corrupt, is also taken away by corruption, as is clearly become visible when they visit the United States. But I don't know about others. I'm sure we all have different points that we took from today's event. Thank you again for being part of this experience, and I'm sure your time, your attention, and your contributions have made this truly valuable meeting. I would like to invite Pusetsov to then do the final closing before we log out. Thank you.
How can I do the final closing after my chair has closed? But just to say thank you, and probably just to say have a good evening, and allow my colleague Price to end the webinar for us. So ladies and gentlemen, have a good day. Bye.